and promoting good governance across Africa. My name is Nico Poku, and I work with CDD, and it's my honor to be here. Before we proceed, I'd like to introduce to you a colleague of mine who is the elections team lead here at CDD-Ghana, Mrs. Rhoda Osei-Afo, to give us a few remarks so that we can proceed. So Rhoda, if you're ready, please take it on.
Oh. I also can't hear.
Nick, I can't hear you. I can't hear Rhoda also if Rhoda is talking.
I also can't hear.
Yeah. Hello.
Hello.
Yes.
Can you see? You can see me, Nick?
Yes, we can see you. Please go ahead.
So we've started?
Yes, Rhoda. We just want to hear your opening remarks so that we can start the program. So Rhoda, please, if you're ready, you can go ahead.
Sure. All right, good afternoon all, and thank you for making time to join today's roundtable discussion, which focuses on presidential election petitions and their impact on Africa's democracy in Africa. As you may be aware, elections have become a fundamental aspect of democratization efforts in Africa, and indeed do enjoy overwhelming popular support across the continent, at least from our Afrobarometer surveys. The continent now enjoys more regular elections, and electoral turnovers have become quite a phenomenon. The conduct of elections, however, continues to face many challenges, and disputed elections is a common phenomenon in Africa. Fortunately, legal provisions in most African countries recognize the law courts as avenues for redress for electoral grievances, and many electoral candidates and their parties continue to resort to the law courts, even if unwillingly, in search of solutions to election disputes. While the outcomes of many of these election petitions have upheld the status quo and left petitioners and some observers disappointed, others, such as the 2010 verdict of the Constitutional Council of Cote d'Ivoire, the 2017 verdict of Kenya's Supreme Court, and the 2020 verdict of the Malawian Constitutional Court, overturned election results and resulted in election reruns. The Kenyan and Malawian court verdicts earned international praise, largely because they went in favor of the main opposition political parties, and many saw the verdict as an expression of the independence of the judiciary in these countries. Over here in Ghana, as you are aware, we have just come out of our second presidential election petition, but there continues to be discussions around the outcomes of that petition. But there's no democracies on the continent. Is there an alternative to these petitions? What has been the posture of the judiciary towards the issues, the parties, and the processes? Do the courts indeed help affirm the will of the people or help pacify parties? Well, this afternoon, with the support of our distinguished panelists who have graciously accepted our invitation, we want to delve into the implications of presidential election petitions on democracies in Africa. On behalf of our Executive Director, Professor Kwesi Prempeh, who on this occasion is a panelist himself, and the management of CDD Ghana, I wish to welcome you all to this important discussion, which follows other previous ones recently organized on different issues of our governance system. I want to indicate that this discussion is pursuant to a partnership between CDD Ghana and the law faculties of KNUST and GIMPA on a project titled Judicial Accountability, which seeks to scrutinize judicial decisions, especially from the superior courts. It is my hope that we'll be able to delve into some of the critical issues that touch on our progress as a continent, which is democratizing. I wish everyone a very engaging discussion and hand you over to our able moderator, who indeed needs no introduction. Thank you very much.
program in conjunction with the law faculties of the Kwame Nkrumah University of Science and Technology and the Ghana Institute of Management and Public Administration. This afternoon, we are privileged to have with us the Dean of the KNUST Law Faculty, Professor Lydia Nkansa, who is going to say a few words before we begin. So, Prof, if you're ready, please go ahead.
Thank you very much, Mr. Nick, and greetings to everybody out there. I welcome you all to today's webinar on presidential election petitions in Africa, which is being organized by the Center for Democratic Development, that is CDD-Ghana, in collaboration with the faculties of law, namely KNUST and GIMPA. And I am very privileged to make few opening remarks. The electoral, the core element of democracy, as it has already been said, is the requirement of periodic elections that's subjecting the executive and legislative arms of the political apparatus to periodic change and reconstitution. Disputes do arise during elections, and unsuccessful candidates and the affiliates do sometimes reject election results. Non-acceptance of election results is registered in several ways, such as demonstrations, outrages, and perpetration of violence, sometimes leading to civil conflict or other complex political emergencies. Some aggrieved persons do also rightly choose the law as their arbiter by petitioning the court. Hence, we have the incident or the phenomenon of presidential election petitions. In the context of election petitions, the judiciary exercises electoral judicial review. And the importance of this, according to International Institute for Democracy and Electoral Assistance, IDEA, is that it safeguards both the fundamental role in the continual processes of democratization and facilitates the transition from the use of violence as a means of resolving political conflict to the use of lawful means to arrive at a fair solution. Electoral justice is anchored in legal frameworks of many African states. Similarly, there are regional and international frameworks on electoral justice. As I've indicated, what the judiciary does is sum up in two main functions. First is the resolution of dispute over electoral rules, ensuring that the rules create a level playing field. And that is, they evaluate the rules. The second is for securing fair play. That is, they are rule enforcing. In this sense, they act as referees of the election petition and decides complaints to redress irregularities and even cancel election results where necessary. Africa, it's already been said, we have had in recent times so many presidential election petitions in Ghana, in Uganda, in Nigeria, Cote d'Ivoire. The courts engaged with these presidential election petitions all over Africa. The courts engagement, we've now had some experiences on electoral justice, which need in-depth analysis and study, since effective resolution of electoral dispute is critical to electoral integrity. Herein lies the importance of today's function. I hope today's deliberations will offer some insight, apart from offering some insight into the phenomenon. One critical thing has to do with the issue or perception of judicial bias in election petitions. In view of the fact that electoral disputes are highly politicized, court decisions on them are likely to be met with skepticism and criticism by the unsuccessful party and its supporters. How? I hope we could address these two other deliberations. How do we work on this as nations in Africa. What do the courts and other stakeholders need to do to eliminate or at least minimize that perception? Again, should electoral alternate dispute resolution, that is electoral ADR platforms, be exploited to complement court adjudication? This is highly debatable because it's been said that election, you have a winner and you have a loser. We don't have to slice the cake. And therefore, ADR mechanism where you need to dialogue and try to arrive at consensus does not matter, because in election you win or you lose. So the dispute resolution should follow that course. So far, if you look at presidential election petitions, it's through the court, it's through adjudication. There are many more concerns of academic and practical importance, which I am very confident that the speakers on this program will do justice to. The outcome of today's exercise, I believe, will be beneficial to our nations in Africa and the world. I look forward to fruitful deliberations. Once again, welcome and thank you for your attention. Thank you.
Professor Lydia Nkansa, she's the Dean of the KNUST Law Faculty. I'm sure most of you are very eager to hear from our distinguished panelists. So without wasting much time, I would introduce to you our moderator for this afternoon's discussion, and then he will take it over. So our moderator for this afternoon's discussion is Mr. Evans Mensah. He's an award-winning journalist. He works with the Multimedia Group. I'm sure if you follow media discussions a lot, he is no stranger to you. So Evans, good afternoon to you. If you're ready, please go ahead.
Thank you very much, Nick, and welcome to all of you once again. Let me quickly introduce my panelists, and I will start from home. And I can see my good friend Yao Pon nicely ensconced in his chamber, is it, or his library. And Yao Pon, by the way, is a private legal practitioner and member of President Akufo-Addo's legal team. Yes, Yao waved there, as you can see him, and that's Yao. In his library there, and he was part of the petitioners team. Sorry, forgive me. That's not the petitioners team. That he was part of the respondents. That the lead, of course, the President Akufo-Addo, who of course had been upheld in that final judgment that was delivered. In fact, it's Dominic Ayine, Dr. Dominic Ayine, who was part of the petitioners team. He is MP, he's a member of parliament for Gatanga East and member of the ex-President Mahama's legal team, as I indicated. Do I have Dr. Ayine? If you were there, can you, wave at us? Do I have him? Or say something, say hello to us. Okay. Do I assume that he's not with us yet and we could expect to have him? Okay. I'm sure when he joins us, I'll get a notification of that. But it's important to say that we expect him to join us very shortly. Also joining us is Professor Kofi Abuchi, another good friend of mine, a Dean of the UPSA Law Faculty. Hello, Prof. Hello, Prof. Professor Kofi Abuchi, can you say hello to us? Okay. Also hoping that he will join us shortly. And we also have Mame Mensah Bonsu. He is a CDD-Ghana and D&D Fellow in Public Law and Justice. Hello, Mame. Can you please say hello?
Hello, everyone.
Great to have you. Great to have you, Mame. Also joining us, and I'm delighted to introduce these two because I've been reading the articles they've written and papers they've written on this, and fascinating insights into jurisprudence generally when it comes to electoral dispute resolutions, as the courts have had, cause to superintend over. Dr. Justice Alfred Mavijenge is the legal advisor, International Commission of Jurists. Hello, Justice. Just give us a wave or say hello to us.
Hello, everyone. How are you?
We're doing awesome, Justice. Great to have you, and I'm excited to to have you join us. And by the way, if you haven't read any of Justice's articles, you want to look for it, because it's exciting to read what his positions have been after he dissected the SADC region and how they've approached electoral disputes. A breath of fresh air as the Supreme Court of Malawi breaks rank with its own precedent and peers in Southern Africa. Part 1 and Part 2 almost sounds like a movie sequel, but read it. It's really fascinating stuff there. And he joins us with that background. Also joining us is Felix Owo. Hello, Felix. That's Felix. Felix waving at us there. And Felix is the Executive Director of the Electoral Law and Governance Institute for Africa. He also has a powerful piece that I was reading, and it talks about, it looks in detail, the very famous Kenyan case that went to the Supreme Court, Raila Odinga, 2017. We watched it here with, great attention, and it's good to have him written quite extensively on it, join us to share his thoughts on how, we could learn from best practice, worst practice, whatever it is. We'll go into that very shortly. And of course, the host himself, and the landlord must be introduced first, but I put him last, and I'm sure he has no problem with that at all. Professor H. Kwesi Prempeh is Executive Director of the CDD. Hello, Prof. Give us a wave. Great, Prof. Nice to have you join us. I would have loved to start with Dr. Ayine, but Dr. Ayine is not with us yet, and so I would go to hear from Yao Pong. And Yao, my question to you is this. Having been part of the team, I mean, you were with the party that eventually triumphed in this matter, the incumbent president, on the opposing side. Having gone through this process from an insider's point of view, a question that demands a yes or no, and then you can then expand it. Has your faith in the courts as the ultimate arbiter of electoral disputes been strengthened or weakened at the end of this process? Is it a yes or no first, before you can expand on that? Is it a yes or no?
Well, I'm not sure what the yes will support and what the no will support. But I will say, and if you may allow me to add another word.
Okay, please do.
Not only been strengthened, I hope you can hear me.
Loud and clear, yes.
It has not only been strengthened, but enhanced. And okay. Yes, if that's enough.
Okay, so that sets the tone. Now, expand for me in great depth why your faith in the court's ability to adjudicate about this matter has not only strengthened your faith in the courts, but enhanced it.
Well, thank you very much for the opportunity. Before the former President Mahama commenced the petition, some of us were on record to have stated that it was very important that the extent to which the disagreement had reached and the level of challenge that even ordinary people, quote unquote, have expressed in the form of demonstrations, and sometimes others had taken advantage of it and had ended up in some violent disturbances and so on. It was very necessary that if it was possible, then a suit ought to have been commenced within the time stipulated by law. And so I was deeply satisfied and delighted when I heard that former President Mahama had thought over the matter and perhaps with the aid of other advisors, agreed or decided to commence the petition to challenge the validity of the election, or as it turned out later, the declaration itself. You will recall that as soon as that was done, or soon thereafter, all the demonstrations and the alleged violent disturbances cease or reduce substantially, because we know the powers of the court. We have the experience of the 2012. The truth is that no one wants to be on the wrong side of the law, and more so the law that is in the hands of the courts, especially the apex court of the land. And for me, the calm atmosphere that it immediately brought to us or restored is something that should lead all of us to commend. And we have done it on a number of times, President Mahama, former President Mahama, for commencing the action in the first place. Because without that, without sounding repetitive, I believe some people would have still not only been dissatisfied with the results, but may have been encouraged or incentivized to continue to engage in some agitations in the manner that a lot of people thought was not, though was their right, but other things could have been more effective. We need to also commend those that were sued, because no defendant or respondent plans to go to court. But when you are taken to court and you believe strongly that the case had no foundation or that there was no case against you, you are compelled to compete and contest. And sometimes, whilst the petitioner or the person commencing the action may have had time to maybe even source for funds, and these things call for a lot of money, you wouldn't have been in that position. But you are to defend if you think you have a strong defense. So we need to commend both the Nana Addo Akufo-Addo, the candidate then and now president, and the Electoral Commission. Also, and perhaps above all, the Supreme Court justices. I mean, sometimes you go to court, start proceedings at 9 and close at 5, with occasional breaks, which would usually not even be more than 30 minutes. And with all due respect, quite a number of them are over 60 and so on. Ordinarily should have retired, but by law, they have the opportunity to serve the nation up to 70 years. Maybe I wouldn't leave out the lawyers. All the lawyers on the legal team, there were research teams, they all did very well. At the end of the day, I, speaking for myself personally, and as a practitioner, we do a lot of litigation anyway. We learned a lot, even though there was limited time, but we ended up learning so much within that period that I tell you, even when you go to your village, the folks there now understand a lot of the processes and procedures to the extent that they are understanding at the level of customary law and so on. And they were even comparing some of the proceedings to what happens in the chief palace, which at the right time, perhaps we can give details. But at the end of the day, significantly, we achieved the purpose. The fundamental purpose for me was not only the settlement of the dispute, but the fact that even where people have genuine concerns about the judiciary, they have, especially at that highest level, one former president, one serving president, and the very important institution as Electoral Commission have all agreed that the judicial system is the most effective, civilized way of resolving matters. It is the final arbiter, and that in spite of all that we will say, the best way, peaceful way to resolve election disputes is the courts. And for me, that is the highest point that we all need to pick up, in my view. We may, in an ideal situation, wish that there shouldn't be any election disputes, but we are human. You know that systems are not perfect. It happens all over the world these days. In America, our friend Trump also did it. There are a number of election petition cases from Canada, in the United Kingdom. So we would have wished that elections be contested peacefully and there will be no serious contentions or, if you like, disagreement that may lead to court. But where we cannot resolve these disputes by ourselves and it will lead to violence or disturbances, then I encourage people that they should go to court. Fortunately for us, and I always say, One of the best gifts that God gave us is an independent judiciary, and even more importantly, independent-minded individual judges that we need to continue to support and continue to let the rank and file understand that it doesn't pay to apply violence, whether after elections or over land dispute or mere recovery of debt. Let us go to the court. They will resolve the matter with our cooperation peacefully, without fear, favor, ill will, or affection. I think that is, for me, is the fact. It's what has made me, that brought me to the resolution that as much as possible, election petitions should be encouraged if we cannot resolve these matters by ourselves peacefully.
Okay, great. Thank you very much. And I think you laid down a certain foundation. And we'll come into the specifics of in what specific ways, looking at enhancement of electoral jurisprudence. The court, it's a case of, as we've heard from the KNUST, somebody must lose or win. But in doing that, did the court take the opportunity to expand the frontiers of electoral jurisprudence, for example, or we're just simply looking into the narrow, whole of deciding who won or lost the elections? We'll come to that. I understand that Dr. Dominic Ayine is with us. Hello, Doc. Can you give us a hi or hello? Hello, Dr. Ayine. Possibly on
yes,
mute. Okay.
Good afternoon to everyone. I'm here.
Great, Doc.
I was having some technological challenges, but I managed to overcome them. So yes, I'm happy to join all of you.
Great, and I must indicate for my friends who are joining us from the rest of the continent, talking about technology, our courts in the Supreme Court petition was forced with COVID, dictating that we had to use technology at some point. And so, I had the Supreme Court judge explain that he had to send a registrar to one of the witnesses. And so wherever he was, that was the courtroom.
Yes,
and so that's a fascinating, I guess, the little ways in which, the laws, was expanded in many sense. Let me bring in, Dominic Ayine, Doc. Before you join, I asked the question of Yao, whether or not at the end of the process, you were in the team of the petitioners, whether at the end of the process, your faith in the judiciary, the Supreme Court, as the ultimate arbiter of the dispute in elections, has been enhanced. Okay, I think that's the word he used. Has been enhanced or has been weakened? What would you say? Do you have a yes or no answer to that question? At the end of the process, has your faith in the judiciary as a final arbiter in an electorate, has it been enhanced or has it been weakened? His answer before you joined was that it hasn't only been strengthened, but it has been enhanced. What would you say? Just a yes or no, and then you can expand first in detail for me why you give him a specific answer.
Well, I mean, unsurprisingly, I would say that I would say no to that. And I say no because building on the 2013 election petition, I expected the Supreme Court, to be more faithful to legal precedent. I expected the Supreme Court, to be more open in the application of the law for purposes of holding the election management body, that is the Electoral Commission, accountable. I expected the Supreme Court to apply faithfully the rules of procedure in terms of the, adducing evidence to prove the petitioner's case and so on. What we saw was a Supreme Court that was, constantly, putting the hurdles in the way of the petitioner in terms of adducing evidence to prove the petitioner's case. And I'm sure for ordinary Ghanaians or the electorate generally, the fact that the Supreme Court judges, all 9 of them, on almost every application, was unanimous in, rejecting and dismissing the case of the petitioner was very telling in terms of the open-mindedness, of the justices as far as the petition was concerned. And for me, as a lawyer, one of the things that I thought, was a bit disturbing was the lack of reasons, okay, because adjudication is a process of accountability. And so for me, it is okay to dismiss an application brought by a petitioner for one relief or the other. Whether, a substantive or procedural. But it is another thing, okay, to fail to apply the rules of procedure in a manner that enhances, the accountability process. Okay, so for me, at the end of the day, the petition actually, dampened my hopes with respect to the independence of the judiciary and its ability, to hold the Electoral Commission in particular accountable in election petitions.
Very powerful points there. I want to bring in now our own neutral arbiters. Now, let me bring in first Mame Mensah-Bonsu, and by the way, Mame is a CDD-Ghana DND Fellow in Public Law and Justice. Mame, so you've had both sides of the coin in terms of their faith at the end of the process. You've heard their arguments. Do you sympathize with any, and what will be your own assessment of the process that we went through in first enhancing beyond the two parties, everybody's faith that the next time, and this is the second time, the next time maybe we have a dispute, this last one should be the reason why we say, don't fight, let's go to court. Well, what would you say in your assessment of that? Did the Supreme Court deliver that promise?
I would say so. I would say that there's always a victor, always a loser. And so invariably, you will expect somebody to be unhappy. But a good measure of whether the Supreme Court's work was by and large viewed as legitimate is the people's response to it. After the decision, did people want to take to the streets and throw things? Did people go home? What did people do when they received? It seemed that people had, by and large, accepted the decision and had therefore legitimized it. So whether you were on the losing side or on the winning side, you have to say, you have to be able to see the contribution that the petition has made to the strengthening of public confidence in the democratic process. Because if nothing else, the amount of time it took for this petition to be ended was significantly shorter than the first one, which suggests that the Supreme Court learned some lessons from the first one and measures in place to make it better. There was a lot of talk in the course of the process about the things that the Supreme Court refused to do and the same things the Supreme Court did do and all of that. Personally, I wasn't terribly sympathetic with a lot of the complaints about the Supreme Court. For instance, when the Supreme Court wouldn't subpoena the EC. I think there are good cases to be made for all of the issues that people had with some of the decisions, but they're not necessarily all bound in the same matter. So public accountability is great, but is public accountability the purpose of this particular petition? Is this the particular forum and the best method? Is this the route to go? Sometimes it would be nice if it happened in the course of, but if that was not the purpose for that route, then the fact that it didn't yield a particular result does not mean that the action was fruitless. I also find that when people talk about independence of the judiciary, and they say that they don't think the judiciary is independent based on a decision, they tend not to add where the dependency is. And I think you can't simply say a judiciary is not independent-minded and not tell us what their influence is and what the motivation for that influence is. Right? You can have a Supreme Court that is cowed by the executive, a Supreme Court that is compromised by personal interests, a Supreme Court that is extremely sensitive to public criticism. All of these are ways by which a Supreme Court could be, on the abstract principle level, that if you are going to make such a claim, you also are under an obligation to show where the dependency is, what kind of dependency is, and why it exists. So yeah.
Great point. Prof, education prep, let me bring you in. I want to move this now beyond the who won and who lost conversation to look at another objective, I guess, that civil society watchers and media watchers hope will also be one of the benefits of this last Supreme Court, petition, which is that are we seizing? Is the Supreme Court going to seize the opportunity to expand and enhance the frontiers of jurisprudence when it comes to electoral disputes, for example? I wonder if you look at it from that point of view, Prof. Would you say our Supreme Court, because especially when this is the second time we are doing this, seize the moment to really expand the frontiers of jurisprudence surrounding electoral disputes?
Is that question directed at me?
Yes, that's to you.
Okay, sure. Okay, so let me approach it from this angle. Prior to the elections, the judiciary, as it had done actually in the past, published an election notification manual, the latest edition of it, which is essentially almost like the source book that puts various stakeholders on notice, essentially, as to how an election petition, if it were to get to the court or to get to the court, would be adjudicated, both as a matter of process, form, and then also as a matter of substance. Now, when I took a good look at the current version or edition of the election notification manual for 2020, one thing that struck me was the absence of any reference to the 2013 Supreme Court decision, which for presidential election petitions is essentially up until 2020 constituted the law of the case for us when it came to 2020 elections. So I was intrigued by the fact that there was there were no excerpts in the manual from 2013. There were excerpts from other cases, mostly, of course, almost all of them parliamentary election petitions. So it made me wonder whether or not the court essentially had concluded that coming out of 2013, the law was essentially indeterminate, that we didn't really know what 2013 stood for in terms of presidential election petitions. So from that point of view, I mean, looking at it from that angle, I think that this election petition, when you read the judgment of the court, at least for me, looking forward, going forward, it appears to bring some clarity, at least on the substance, right? The court made reference to Morgan versus Simpson approvingly and appears to embrace that as the new law that is going to govern how the court approaches election petitions, at least in terms of the substantive grounds on the basis of which a petitioner might actually get the election results annulled. And I think that gives us some clarity. I think one of the virtues of an election petition judgment is that it must give us clarity as to what the law of the case is, so that going forward, stakeholders and parties and counsel are sufficiently apprised of the things that they must show, the evidentiary burden that they must carry in order to get a court to annul an election. And I think coming out of this election, I would say that on that score, there was a positive improvement. Clearly, there was an improvement upon the 2013 jurisprudence, so to speak, because I don't think there was much clarity coming out of 2013 what may have been in the law of that case. And that may well explain even the petitioner's the court had some difficulty initially trying to answer the question whether this looked like a real presidential petition at all. The court said, well, you're not asking for anything to be annulled. You are not asking for an election to be annulled. You are just asking for a declaration or some CI to be annulled, and that is not like an election petition. But I can sympathize with that because coming out of 2013, the court, based on the election petition manual, the election activity manual doesn't even appear to me to have a clear sense of what the law is. So on that, I think I would say, yes, we have some clarity now, at least I do, going forward, what it is that an election petition must show to be successful in court, some of it. One area where I think there's still not much clarity, and I would say I look for an election petition to do two things. First, to give clarity as to what the law is, but also to actually, because elections are a very peculiar kind of, election petitions are not just any ordinary case. So one of the things I think I look for them to do is also to help us improve through the election outcome and the decision of the petition. It should help us improve the conduct and integrity of our elections going forward. That is one of the functions, one of the public functions of an election petition. It should not just resolve a particular case today, but resolve it in a way that helps us improve the conduct and integrity of our elections going forward. And on that score, and I'll have an opportunity to say that, I think that there is still room, a bit of room for us to travel on that second leg.
Prof, you just touched on, I guess, the Holy Grail, which really was at the heart of this whole process in the 48 days. And I want to bring in Dr. Justice Alfred Mabijenge on this. And it revolves around, and Dominic Ayini and Yao can also chip in at some point on this, about the appropriate standard of proof. The test, how you evaluate the evidence and what evidence you require to actually convince the Supreme Court that your case should be upheld, either to overturn the result or whichever way it is. And Justice, you, in the case of Malawi, studied the case. And by the way, in the Malawi case, the Supreme Court mastered the courage against what is known on the continent. And we've heard Dr. Ayini say that about the independence of the judiciary, almost petrified to go against what is perceived to be the will of the people as expressed already through the ballot box. But the Malawian case, the Supreme Court overturned that result. In your article, you analyzed the subject of what the appropriate standard of proof is. What did you find in the Malawian case, Justice? Because this will have a lot of resonance for us because it was key. And I saw the petitioners in Ghana, always the evidence they brought. In fact, the question I was asked them, if you had your own alternative election results, why didn't you bring that? Because you're challenging the declaration, and in essence, the result. It was a mathematical question. And so where is your own independent marks in the matter? It's a question of evidence. I mean, what did you find in the Malawian case when it came to what the appropriate standard of proof is?
Thank you very much, Comrade Moderator, and I'm very grateful for the opportunity to speak here. I salute Prof. Kwesi. It's good to reconnect virtually. The last time we spoke was in Kenya when we were dealing with similar issues. Look, let me say, I think to talk about first is the legal test before we talk about the amount of evidence and the types of evidence and so forth. So in the past decade or 2 decades, we have had basically about 3 cases that have been decided in the Southern Africa region I'm obviously not going to talk about Uganda and Kenya because you have a panelist on.
Justice, forgive me. Kindly turn on your video for us.
Oh, sorry. I thought my video was on. sorry. I'm sorry about that. Am I clear now?
Yes, you are.
Yes.
You are. Yes, you are. We can see and hear you.
Fantastic. So I was saying, in the last 2 decades or so in the Southern Africa region, there have been 3 major cases that have been decided on this question. Obviously, I'm not counting Kenya and Uganda because you have a panelist who will speak on that. But if necessary, I can come back to speak on that as well. But for now, I'm just going to focus on what has been sort of decided by the courts, the superior courts in the Southern Africa region. So we have 3 cases. Back in 2000, there is a Zambian case which was decided by the Supreme Court of Zambia, in which the results, in which President Levi Mwanawasa's victory in a presidential election was challenged. So the title of the case is Anderson Kampela Mazoka versus Levi Patrick Mwanawasa. Then fast forward 2018, in my own country, Zimbabwe, the victory of President Emmerson Mnangagwa in July 2018 was then challenged by Nelson Chamisa in a case that was decided by the Constitutional Court. And then in 2019, the High Court of Malawi actually was the first to decide to come to a decision which overturned the presidential election results. But then in 2020, the Supreme Court of Malawi upheld the decision of the High Court of Malawi. So many times when people are talking about the Malawi case, they overlook the decision that was made by the High Court. In fact, it is the High Court which made the initial decision, and that decision was upheld on appeal by the Supreme Court. Now, the battle in the region in Southern Africa has been between the courts which believe in what I characterize as the qualitative test against those who believe in what I characterize as the quantitative test. Now, what is the qualitative test? The qualitative test is basically the idea that a petitioner who wishes to invalidate election results should prove to the court that there are, number one, clear irregularities in the way the election process was conducted or the results were counted. And number two, those irregularities amount to a substantial departure from the electoral law. That is enough to invalidate election results. That is the test that was largely applied by the Supreme Court of Malawi in the 2019 and 2020 case of Peter Mtaruka versus Lazarus Chakwera. So I'm calling it qualitative test because it doesn't involve an inquiry into whether there was a quantitative impact on the results. This is the quantitative test. The petitioner is required to go beyond simply proving that there were violations of the law during an election or that there were widespread violations of the law during the election. One must prove that those violations had a substantial impact on the election results. So that really has been the battle in the region. The courts which took the quantitative test approach are the Zimbabwean Constitutional Court in Nelson Chamisa versus Mnangagwa, and also the Anderson Kampela Mazoka case in Zambia. So the Zambian Supreme Court and the Zimbabwean Supreme Court have endorsed the quantitative test, whereas the Malawian Supreme Court and its High Court have endorsed the qualitative test. And it is also important to note that the Supreme Court of Malawi has actually departed from its own precedent on that particular issue, where in the past they were leaning towards the quantitative test, and now they are following the qualitative test. Now, if you ask me which of the two, or why do we have that kind of a debate going on? That debate is going on because electoral law in the region, I'm sure this might be the case in other regions as well in Africa and beyond. Electoral law is not very clear on which test should be applied. And in my view, this is the conversation that I think academics and practitioners of elections need to have, so that these issues are clearly taken care of and laid out in the law, so that there is no debate about which test should the court apply. Because in most cases, these tests are not clearly laid out in the law. And that's why the courts then have to grapple with what the appropriate test should be. I don't know if
So should I ask you, and very briefly, so having analyzed all this in the SADC region, which of these two approaches would you say will yield the best outcomes for the democracy, right?
It's a difficult question, but I think if in the first place, I mean, we need to be able to balance between the reality that on one hand, for elections to be considered as fair, they must be held in accordance with the rules. Otherwise, there's no need for rules, right? If we are going to then say, yes, we note as the court that there were violations, but can you prove to us that the violations distorted the results? No. The reason why we have rules, first and foremost, is because we want elections to be held in accordance with those rules. But also, on the other hand, we should appreciate the reality that a national election is a massive logistical exercise. So there would be irregularities here and there, right? But in my view, when irregularities become so widespread, right, it begins to point towards an intention to manipulate the electoral process and subvert democracy. And therefore, the best test for me is the qualitative test. As long as we agree that the qualitative test should not be a test which allows a petitioner to simply allege that there is an irregularity and therefore this election result must be invalidated. No, one must first establish that there were clear irregularities. Two, those irregularities, do they amount to a substantial, not just a departure, but substantial departure from electoral law? If it does, then I think the conversation should end there. Because it means, as Lillian Tibatenwa, one of the judges in Uganda said a sham election should be exposed for what it is. In one of her dissenting judgments, she said a sham election is not an election. It is an attempt to have an election. So if an election is conducted without adhering to electoral rules, then it's not an election. So, and this is why our electoral management bodies should be capacitated enough, both technically and funding-wise, for them to be able to carry out their mandate.
It's 16 hours.
Yeah.
In strict compliance with the law. I will end there for now.
Great, Justice. And so you set the tone there. I mean, fantastic points. And I'll come back to ask both Yao and Dominic, which of these two approaches, the Ghana in the two election petitions, I can bet I know what they'll say. I think it's more quantitative than the qualitative. But I dare introduce a third test, which I'll call the substantial test. In other words, both qualitative and quantitative must be substantial enough to have any impact in the outcome of the elections. I think I hear Justice saying that whichever test you apply, there must be an element of substantialness, if there's any word like that, for it to make any meaning. really, because you just can't come and say it broke the law. So let me bring in quickly Felix Howard, because Felix, you had a Kenyan example, and you also wrote extensively about it. And from what I see, Kenya also applied the qualitative test, did they not? And not surprising that they also overturned an election.
Yeah, you are right. Thank you. First of all, thank you very much, and greetings to everyone. Greetings, Prof. Yes, you are spot on that observation with respect to the Supreme Court judgment of 2017, and that is the application of applying the qualitative test in validating the presidential elections of 2017. And I think it should be appreciated that that was a departure from their decision of 2013, where the Supreme Court of Kenya, like other Supreme Courts in the continent, in cases that have been cited here, the Nigerian Supreme Court, the Obasanjo case, the Ghanaian case, Nana Dodankwa case of 2013, or the Kiza Besigye case in Uganda, and other cases. So what the Supreme Court of Kenya did in 2013 was the elevation of the quantitative test, what we call and we are in Kenya as the doctrine of substantial effect that emanates from the UK electoral laws. And so what the other courts, but more so Kenya in 2013 did, was the preoccupation with numbers. And the truth of the matter is that if you look at the contestation around Africa and Kenya in particular, if the numbers were to be the sole yardstick as a farm or as articulated by, for example, the Nelson Chamisa case that was mentioned there, where the Constitutional Court of Zimbabwe say that numbers were the sole yardstick, then I can promise you no election would be invalidated in Africa. There is no incumbent or electoral commission in this continent that cannot be able to get numbers to bridge or to add or to top up to an election. So in 2017, the Supreme Court of Kenya took a completely different view. And that is the application or applying the qualitative test in examining the threshold for invalidating the elections. And the challenge that the Supreme Court had was the so-called, the question of the test, whether the election itself was held substantially in accordance with the laws, or that the illegalities and the elections had substantial impact on the results. That you don't have to approve both, that it was enough or that it is sufficient to prove one or the other. And applying that test, therefore, the Supreme Court of Kenya then invalidated the presidential elections in 2017. But even before doing that, the Supreme Court also dealt with the question of the burden of proof in a manner that was a departure from Supreme Courts or constitutional courts in the continent, whereby the test or the standard that the Supreme Court came up with was that the evidentiary burden lies on the petitioner to prove that there were irregularities and illegalities. But once the petitioner had a sufficiently adduced evidence to warrant impugning an election, then that evidentiary burden then shifts to the respondent to rebut that allegation. And we saw in earlier cases, the Besigye case in Uganda, or even the cases in Nigeria, etc. I think in Ghana in 2013, the evidentiary burden did not shift to the petitioner, to the respondent. And so when it shifted, and I'm glad somebody said that you followed the Kenyan case. I think it was you, Mr. Chairman. You could see where, and I have videos that I can share with you, where the respondents advocate were unable to rebut the evidence. For example, in the use of technology or the results themselves and things like that. So if you look at and I think I should say also that the Malawian case that followed heavily relied on the Kenyan case or the Kenyan decision in 2017 in dealing with this question of substantial effect doctrine, or what my brother there said, the debate between the qualitative versus the quantitative. In fact, the Malawian Supreme Court was even more authoritative about it. But I think it's worth saying and noting that that was probably the greatest contribution of the Kenyan Supreme Court on electoral jurisprudence in Africa, that one needs to apply disjunctively or read disjunctively substantial non-compliance and whether the non-compliance affected the result.
I mean, Felix, let me also ask you very quickly, which of these, having, of course, also studied this, which of these two approaches then would you recommend? I mean, both for Southern and for the continent broadly? I think
the qualitative approach, the Kenyan jurisprudence in this regard is spot on. That election is an event, is a process and not an event. It is not simply about numbers.
Okay, great. Let me come back to Ghana, and I know there are a lot of you who want to chip in, but I want to start with you, Dominic Ayine. Dominic, it is obvious to me that in the two petitions that we've witnessed in Ghana, our courts have leaned heavily towards a quantitative test. If you agree with that position, should it remain? Should we maintain that, or it's time for a shift in the way our courts here assess and test the evidence? What would you say? Hello, Dominic. You may have muted. I see you still muted. Dominic Ayine, if you're still there. Hello, Dominic.
Yes, I'm here.
Yes.
Yeah, thanks.
Is there time to shift?
Good. Well, I don't think so, but it depends on the nature of each case. Okay, the justice of the case will depend on the circumstances. It will depend on the facts and the evidence that has been brought before the court. Of course, the 2013 election petition merited the use of the quantitative test, and that was because the petitioners in that case were alleging substantial irregularities, such as, presiding officers not signing, the declaration, the results declared, the pink sheets, okay, polling station codes that, were wrong, okay, or not that did not tally, and so on and so forth. And because they were asking the Supreme Court to annul results in, I think, over 11,000 polling stations. Okay, the court was drawn by the nature of the case towards the use of the quantitative test. Okay, so that is how come the court asked itself whether or not there was, compliance. There were irregularities that had been established by the petitioners, and whether or not, and the extent to which those irregularities affected the results to the extent that the court would have to annul results in those polling stations. And so I would say that it depends on the nature and circumstances of each case that comes before the court. But of course, I would lean more towards the use of the qualitative test, okay, because as Justice rightly pointed out, the reason why we make laws is because we think that there are normative arrangements that must guide us in the conduct of all our public affairs, including the conduct of elections. And so if you can show that the laws have not been complied with, all right, or that there has been substantial non-compliance with the law, that in and of itself should be, in the conduct of an election, that in and of itself should be sufficient in order to for the Supreme Court to say that the election be set aside. But before I end on this point, I need to point out that in the Ghanaian 2020 petition, all right, if you have to compare what the case that was brought in 2020 to the case that was brought in 2012, you will be comparing apples and oranges, all right? And that is how come that in this case, I think that it was wrong for anyone to assume that the quantitative test, for instance, can be used, all right? Because as I kept saying in the briefings to the press, anytime we came out of court, that this was a case that was qualitatively different from the 2012 petition. This was a case concerning the mathematics of Article 64 of the Constitution regarding whether or not, okay, a candidate had obtained more than 50% of the votes. So it wasn't about irregularities and non-compliance with, let's say the public elections regulations and so on. It was about the mathematics of the election, okay? And a different standard ought therefore to have been, applied in determining whether or not that constitutional threshold had been met. So an attempt to apply the 2012, standard, and that is why I'm very happy that Prof. H. Kwesi Prempeh made reference to the weight of precedent and the fact that the current decision brings some clarity on certain aspects of elections law that we missed out in 2012, because in 2012, okay, there was some assumption that the ordinary laws of evidence would, apply in making a determination, okay? In this particular case, the court's attention was drawn to a number of issues, relating to the burden of proof. And I think that is how come that the court, came out making some clarifications relating to, proof in electoral matters.
Yeah, and I'll come to you, Prof. and Mame, very shortly on a question that I think dominates, accessions there raises, which is that should the reliefs sought dictate the approach? And I think he almost suggests that maybe the relief should. Prof. and Mame, I'll come to you shortly to address that for me, very briefly, 2 minutes. But Dominic, I want to stay with you for the next 2 more minutes, because there's something that you said on your opening remarks that Mame touched on that I think we need to get you to clarify. You raised the question about judicial independence in the way the process went for us. She challenges you to explain what you mean, define it, but also if you say that they were not judicially independent.
The election petition conduct a survey, a public survey, a poll of perceptions of independence of judges, the judges on that particular panel, all right? And I'm sure there will be empirical, there will be responses that point to the fact that people perceive that the judges were not being independent, okay? Because, just look at how the justices dealt with the petitioner's case, from the beginning to the end, all right? You can, I don't want us to go into the legal merits of the applications and so on. For lack of time, but if CDD wants me to present a whole paper on that, I'm prepared to do so, all right? So, what is, for instance, wrong, in allowing interrogatories to be administered, okay? For instance, to the Electoral Commission, okay? What is particularly wrong in allowing the Electoral Commission, to answer a notice to admit facts and so on and so forth, all right? The fact that the notice to admit facts was filed and served on the petitioner and the court went silent on it, is itself very telling about the independence of the judiciary. And you can draw irresistible inferences from the conduct of the case about the independence of the judges. And I'm entitled to that view. That is a view that I have taken. My
challenge to you is, so if they're not judicially independent, somebody must be interfering, and who is? Because he said you cannot raise that question without proving that there's somebody interfering.
Look, I don't want to, I already got into a lot of trouble speaking after the court matter. I don't want to be quoted as having said that somebody was manipulating the Ghanaian judges behind the scenes. I have made my point sufficiently clear that you could draw inferences from the way the justices handled the matter that they were not being independent. That is a position that I'm ready to take publicly.
Okay, great. Let's move on now. Let's come back to Prof. and Mame. On that question I asked.
I've been quiet for too long.
Yeah. Yeah. Okay, no problem. Prof. and Mame, just give me a second. Let me hear from Yao. Yao, yes, give me your thoughts on that very important point about qualitative versus the quantitative. Anything else in the next 3 minutes? Go.
Yes, but before that, I think I fully share the view of Mami, and it is with pain that I have to disagree with Dr. Ini completely. He's really, in my respectful view, out of order, if I may be permitted to say so.
Oh.
Because if I may be permitted to say so, with all due respect, I think that, and that's my me challenge you, if you are unable to pinpoint, give specific, provable events or evidence that the judges gave certain decisions because they were not independent, and they were not independent because there was interference or because they depended on the view of a person who is in a position to influence their decision, then I think that, with all due respect, that position is far-fetched and doesn't cut us at all. But in any case, I mean, I grant that you are entitled to your view. Now, going back to the petition, I mean, there is a profound statement by the Kenyan Supreme Court, if that's, you may allow me. They appear to adopt what I call a hybridized system of proof of evidence and all that. So they say, quote, "We maintain that in electoral disputes, the standard of proof remains higher than the balance of probabilities, but lower than the beyond reasonable doubt." What it means is that in ordinary civil proceedings, and this is the Raila Odinga case, in ordinary civil proceedings, we apply the balance of probabilities. Could it be this or that? And then in criminal proceedings, we apply proof beyond reasonable doubt. But they are adopting what I call the hybridized system, where they say that because of the nature of election petition, very unique of its own, there is the need to raise the bar beyond the standard, the balance of probabilities, but below beyond reasonable doubt. In our case, the courts have held that generally we apply the balance of probabilities, which is generally applicable to ordinary civil proceedings. However, where there is an allegation of the commission of an offense, and as it pertains in even land matters, like fraud is alleged, then the standard for proving that criminal allegation in a civil matter is proof beyond reasonable doubt. And so if there is an allegation that somebody snatched ballot boxes, quite a number of them, or that any of the offenses in PNDC Law 284 are, if you like, the Parent Act, even though the most parent, if I may call it, the Constitution, but the specific act for our election, the conduct of election, especially parliamentary elections, 284. But if, for example, any of those offenses are breached or violated, then it is the criminal standard that will be applied and not the ordinary civil standard of proof beyond or the balance of probabilities. But even in that case, just saying that our own court, the Supreme Court, has held in one case, Koyenya and Nacha, that when it comes to constitutional matters, the standard of proof is very high since the Constitution, I'm quoting in part, since the Constitution 1992 is the supreme law of the land, which the defendants have all sworn to defend. And any violation of its provisions is normally punishable. The standard must therefore be equated to that required in penal cases. This would demand the plaintiffs, in order to succeed, that you must rely on the strength of their own case by proving beyond doubt that the actions of the defendants have provoked their action, that provoked their action is unconstitutional. Any weakness, therefore, in the defense case should not avail the plaintiff. But as I said, when it comes to our system, we will generally apply the hybrid system, not that like that of the Kenya, but in the sense that once there are not mere non-compliance, but non-compliance that go into violation of the penal provisions in electoral laws, the courts will apply the proof beyond reasonable doubt standard, which will mean that not only must you establish that there have been some violations of such penal provisions, but you must also establish clearly that those violations are just not insignificant, they were substantial, and to the extent that without those violations, the results declared would have been different, completely different from what have been declared. And that those violations had, if you like, benefited the person who has been declared, to the extent that if you deduct the consequences of those violations, the consequential results of those violations, the person declared president would not have been declared president. And so that is what I think we have. In my view, it does not necessarily depend on the nature of the case. In this case, for example, as Dr. Inik articulated perfectly, there was an issue as to whether or not there were violations of these relevant rules and laws, and to what extent did they have substantial impact on the results.
Okay, I mean, hold on for me. Let me bring in Prof. Prof, 2 minutes to you and 2 minutes to Mame on this question. I think both Dominic and Yao seem to suggest, and they can correct me if I'm wrong, that the nature of the reliefs should almost dictate the approach you adopt. Do you agree? Or what would you say to that? Professor H. Kwesi Prempeh, that's a question to you. Hello, Prof.
It's mute.
Prof, can you mute? Yes. I wonder if you had a question.
Well, I think it's really not just a question of the relief that you're seeking, because basically in an election petition, the standard relief is annulment. Right? You're actually in court. You're actually in court because you think that the election results do not reflect the will of the people, and therefore the standard, the very first relief you're asking for, as a matter of course, is for the election results to be set aside. So the relief alone, I think that it's important to say that this debate about qualitative versus quantitative, it's not an either-or issue, right? The Morgan versus, all of this comes out of Morgan versus Simpson, Lord Denning's opinion in 1974 decision in Morgan versus Simpson. And in Morgan versus Simpson, he actually lays out these tests in a way that are disjunctive. So what he's saying is, if you go to court alleging that there were substantial violations and irregularities of a kind and scale that essentially taints the outcome, so taint the outcome that we cannot consider the outcome legitimate. We are a cast doubt as to the true outcome. Then you have shown substantial non-compliance, and that by itself is sufficient to set aside the election. However, even if you are not able to show that the election, there's substantial non-compliance, right? And you were able to show that the elections were substantially in compliance, but certain things happened in that election, right? If you are not able to show substantial non-compliance, then you must show us that whatever did happen affected the result. So essentially, it depends on what you go to the court with. If you go to the court with a qualitative case, then of course the court will expect you to show substantial non-compliance. So if you go to the court, and I think that in our lay language, we say free and fair elections, right? Free, you must show free, the elections were free and fair. Translated into law, I think that the free part is, for example, saying that, you must show that the elections were substantially in compliance with the law, right? The free part. And to get over that, then you must show that it's fair as to the outcome, the result. So Justice Lord Denning actually anticipated both the qualitative and the quantitative test. I think that the reason why we are holding this is not an either-or choice. If you go to court in Ghana with a quantitative case, the court has no choice but to ask you to show the effects on the election results.
So you're saying that it depends on the nature of the petition?
Sure, it absolutely has to depend on the nature. So if you go to court, for example, and say that, look, in this election, right, remember too that the test in the common law jurisdiction, the leading case is a parliamentary case, actually a local government case. This is one thing that we miss. The leading case, Morgan versus Simpson, is a small electoral district. It's not the national boundaries, right? Presidential elections based on a precedent and a doctrine carved in parliamentary or local government election actually creates a lot of havoc, right? So you should notice that in 21 days, you are supposed to canvass all of these polling stations and collect evidence and come to court, right? Now, assuming that you were able to collect evidence in, say, 50 large constituencies out of our 275, and these are large enough that, let's say, urban constituencies, you are able to show that, look, there were such massive irregularities in these 50 constituencies in Accra, in Kumasi, Ashanti region, and all these large places, right? But you cannot actually show the effect, the exact effect on the election. But you can show that the elections were so substantially bad, right? They were bad in real substantial ways, not just people didn't sign stuff, but that ballot stuffing was happening here and there, all these things were happening, and the cops were looking the other way, and everything happened. If you are able to show that the election was so hopelessly bad in the way it was conducted, then you are making a qualitative case. You are saying that the elections, in fact, could not be said to have been free at all, right? So that's the case you are making. And the court have no choice but to apply the first leg of the Morgan versus Simpson test, which is a qualitative test. But if you go to court and say, yes, we know that the election looked free, it was free, generally free, almost Codeo has said so, everything, but the test, the result in this case, we can bet you was incorrect. Then you have to show the effect. Exactly. So it depends on the case you go to court.
Yeah. Let me bring Mami. You have 2 minutes to expand on your thoughts on this, and we can move on to quick other things. And hello, Mami. Yes, Mami. Kindly unmute if you have. Do we still have Mami? Hello? Okay. I'm going to quickly shift then to another big conversation. And I see that I have Mr. Kutompao with us. I'm told he's joining us. Okay. Sheshe, do you want to say a word on this all-important conversation about jurisprudence and what our courts should normally, should broadly do in weighing the evidence and the standard of proof?
Okay, I agree completely with Kwesi Prempeh. It depends on the nature of the case sent to court. That is what will determine whether or not the court will apply the so-called qualitative test or whether it will apply a quantitative test. And I do not think that very much would be advanced by trying to suggest that the qualitative test is the proper path as against the quantitative test or the other way around. I don't think that. It depends on the nature of the case that is brought to court and the evidence before the court.
But I guess it sums it up for me. I want to now move, and I want to now move to one of the things we need to also look at is how these cases help us improve the election management system itself. Yes, Prof.
May I interject here on this side debates about judicial independence?
Independence, okay. Have it.
I think it's important to underscore that, look, independent judges can produce bad jurisprudence, and compromised judges too can produce bad jurisprudence, right? So, but it is difficult to go from the jurisprudence to then make inferences about independence or lack thereof, right? So it's usually a very tricky line to walk. You know, when this whole idea of election petitions started, and in the common law world, it began in 1868. Before 1868, election petitions were held in Parliament. Parliament was actually, Westminster Parliament sat on its own disputes about whether or not a particular MP had been properly elected. It was in 1868 that the Westminster Parliament decided to transfer, to basically move the matter, because they were so hopelessly divided as a political body, unable to adjudicate these things fairly, that they moved it to the courts. And let me say something about the court's reaction. The Lord Chief Justice at the time was Sir Alexander Cockburn. He was incensed at the suggestion that the court should be handling political election disputes because he thought these were inherently political disputes and bringing them to the court would be bad. This is what he said. The confidence in the court will speedily be destroyed if after the heat and excitement of a contested election, a judge is to proceed to the scene of the conflict while men's passions are still roused. The decision of the judge under such circumstances will too often fail to secure the respect which judicial decisions command on other occasions. Angry and excited partisans will not be unlikely to question the motives which have led to the judgment. Their sentiments may be echoed by the press. This is 1868, the Chief Justice of UK objecting to the courts taking jurisdiction. So this whole debate about independence and all of that was actually anticipated. The courts knew that bringing them into this inherently political dispute would raise questions about judicial independence and politicization of the judiciary. So it's something that I think we should accept as standard. Each time you judicialize a political game, like an election, you are bound also, the judiciary is also bound to suffer a certain perception of having been politicized. So it's not at all strange that we are having this dispute. But all I'll say is that we cannot easily go from the case outcome to infer independence or lack of independence. We should take the jurisprudence on its own terms and scrutinize it, analyze it, debate it, without necessarily impugning motives as to how we came to the result. I think it's fair to say that people can differ as to the outcome, but it doesn't really have to lead us to make the other inference that I think my good friend has been trying to make.
Great. I will quickly want to move on to one last plank of this conversation, then I'll open the floor for everybody to contribute to that question.
Evans, before you go to the next person, yes. I think, yes, I want to.
I'll give you a minute.
1 minute. Just 1 minute.
Yeah.
The point that Prof made is a very valid point, but it is not one that is based upon the reasons that I gave, in the sense that I wasn't talking about the outcome, all right, of the applications or the outcome of the decision as a whole. I was talking about the process, all right, involved in arriving at the outcome that gave the perception of lack of independence or bias against the petitioner. That is the point that I'm making. And I believe that, Prof shouldn't have missed that.
You are muted.
Yes.
Oh, sorry. I want to look at how the petitions themselves help improve the election management systems. And I want to quickly come to, do we still have Mame there with us? Okay, if we don't have Mame, I want to quickly go to Felix. Felix, quickly address it for me, and then you strictly have 2 minutes. 2 minutes to address this from your experience. The outcome of the Kenyan case, for example, to what extent did it enhance the efficiency of the election management body there, the process itself of elections? In what specific ways did the case do that?
Well, I think it enhanced citizens' confidence in the judiciary as an institution. And in terms of public perception, judiciary is rated up there. But it also has to be appreciated that soon after, there were political consequences that followed following the Supreme Court judgment. Threats, intimidation, and in certain instances, you know, the executive and the legislature going out of their way to intimidate the judiciary. Now, very little was achieved in terms of strengthening the election management body. And this is because the Supreme Court of Kenya, in its judgment, fell short of making very far-reaching radical recommendations to improve and strengthen the election management in the manner that the Supreme Court of Malawi, for example, did. And but it is work in progress. Recently, we just concluded a 2-day retreat with the Supreme Court and the Electoral Commission. And right now, we are in the process of unpacking the impact or the jurisprudence that emanated from the Supreme Court judgment, with a view to isolating far-reaching recommendations to strengthen the electoral process and election management body, including the resilience of the judiciary and the Supreme Court itself. Thank you.
Great. I mean, no, Justice, there's a question that we've been grappling with here in Ghana, which is that the election petition itself, some have argued, is such a unique process that the courts must also adopt unique ways of assessing or arriving at the outcome. So, for example, down with us here, the electoral commissioner the court said they cannot simply compel a person to testify, which is, they believe, a settled principle in law. There were those who argued that you cannot apply that principle because this is such a unique case, it's a unique trial. And it begs the question, should election petition cases, should the courts appreciate the uniqueness of the thing, and therefore, in the way they assess, and apply the law, also be mindful of that in I guess, being creative, so to speak, in application of the law. Well, what do you say to that?
Thanks, Evans. Maybe before I attempt to answer that question, I just want to give share my views about the argument that the test that should be used by the court should depend on the nature of the.
Yeah, I would like you to do that in a minute, if you can, because of time.
Yes.
Briefly.
Whilst I agree with Prof. Kwesi and the other speakers that certain cases that the court must apply the appropriate test depending on the facts of the petition. But I think also in reality, we should not forget that not many cases are clearly quantitative or qualitative. In fact, the majority of the cases raise qualitative and quantitative arguments. Let me give you a very good example. In Zimbabwe is divided into 12 provinces. And in 2 provinces, there was a lot of violence, and where people were being tortured, and there were, pictures and photos of, victims of this violence being beamed on social media and on televisions. Now, whilst one can say that violence was confined to one province and should therefore cannot therefore be said to have affected the results from the 9 provinces or from the 10 provinces. The reality is that the photos that were beamed of people with wounds coming out of torture could have had an impact on other voters in other provinces. So it's not always clear. It's not always easy to say this particular matter is quantitative, this particular matter is qualitative. This is why I think it's a conversation that maybe organizations like CDD need to actually consider facilitating so that people can discuss this matter in depth.
Great.
Now,
great
to
point.
your question,
I mean, should the courts adopt new rules of evidence and civil procedure, appreciating the uniqueness?
I think elections, except where criminal allegations are being made, such as fraud and physical assault and all those things, elections cases are a civil matter, right? And I think civil rules should be applied. Of course, the rules of justice the demands of justice may require that here and there, the courts should be flexible to do whatever that they can within the confines of the law to ensure that justice is delivered. But the biggest problem, if I may sign off on this one, the biggest problem for me is when the court is not consistent. The court must be consistent in the way that it deals with the matter, right? And once you do that, then it becomes easier for the petitioner or the litigants to know what they need to do in order to satisfy the requirements of the court. But the courts are hardly.
Okay, I want to quickly bring in everybody else now. If you have a question or contribution, this is the time to chip in. Simply introduce yourself and please make the contribution strictly down to a minute. 60 seconds, very strictly, or question. We'll take it. Who is going first?
Okay, if I may, Evans.
Yes, please, Dr. Aine.
Okay, so when I was giving the concept note, I thought that we were going to focus on how the petitions, as a species of political contestation, will deepen democracy in Africa. Okay, so one of the key points that I wanted to make at this point is that, of course, election petitions are political in nature, all right? And depending on how the adjudication is handled, it may or may not enhance or deepen democracy. But the value of the petition as a mechanism for deepening democracy, lies, in the manner in which, the petitioners and the political elite, handle the communication with respect to a petition process, and then how they affect public opinion with respect to the merits of the petition, with respect to the conduct of the judges, and then the conduct of the respondents in particular. And so I think that, there are other things, other variables that we must look at when we think of, the consolidation of democracy in Africa. And then also, if we are looking at the petitions, in and of themselves, deepening democracy or entrenching democracy, then we have to look at them in a holistic manner. That is the point that I wanted to make.
So maybe I should ask this broad question: in what specific ways, for example, did the 2020 petition, help improve our democratic structure as it is right now? Anybody would like to take that? Because that is fundamental. Has this almost guaranteed that our 2024 election will be better? Than the previous one. Anybody can take that.
Yeah. Can I? Yeah, we're here.
Yes, please.
Right. So, I think first of all, apart from the general benefit, I think even lawyers, you'll be surprised to know that most lawyers, even a lot of us, didn't know that in a civil matter, you can in a way apply for submission of no case or a proceeding that will lead to the matter being truncated at the point where the defendant doesn't have to give evidence. We had thought that it only applied in criminal cases. So even for the development of legal education for lawyers in particular, and the ways in which these applications were brought, it opened up a lot of the avenues, the frontiers were opened. I mean, a lot of research had to be gone in to go into it, especially by the petitioners and their legal team, which then also compelled the respondents and their legal team to also go into serious research. And I think that when you read the various submissions, which, if it's permitted, I always that the judiciary or whoever may give the permission should allow that the written submissions by both the petitioners, the respondents also should be published. And people will see the extent of the expenditure of energy and other resources that were put into it. Then also, I think that not just this 2020 election, the 2012 election petition, in fact, led to a lot of the reforms that we saw in the 2020 petition. You remember Justice Doche's roadmap substantially were featured in the presidential election, the manual on election, which Prof referred to at the beginning of his submission. But I said that, Prof, with all due respect, I think the Supreme Court 2012 presidential election petition was referred to from page 72 to page 75 in the fourth edition. Though it may not be substantial, but the views of each of the judges on the the signing of the declaration forms, if that is so, the presiding officer signing, all the views of all the judges have been reproduced in those pages that I just referred to. So I think that with that reform, we were able to now get a law to say that, well, only the person only a candidate can challenge presidential election petition. That is still debatable because the Constitution says a citizen of Ghana, but that's what we got. And that only the person whose election is being challenged should be a respondent, and also the Electoral Commission. Remember 2012, even I think in excess of about 300 or so persons wanted to join. And I think in a way, the Justice Doche, for example, stated in the final decision that even a joinder of a party to be third respondent may not have been granted or should not have been granted. So I think we have benefited quite a lot from the 2012 election. That is why I hold the view that if it becomes a last resort, let us go to court and challenge the elections. If for nothing at all, it will deepen not only the faith we have in the courts and the judges, but also the electoral rules. Mind you, it may come just once in 4 years, and we may have even forgotten about all the important things. Then also, especially the last one, lawyers were given opportunity to explain, even in the vernacular language or the appropriate non-English languages. And I think that also the opportunity given to the whole world to watch brought justice to the doorstep of the people, even in the villages where we come from. People now have, it is as if there is some demystification of the judicial process, even though the law is very clear that justice emanates from the people and should be, as it were, enforced or exercised or practiced in their name.
Yeah.
But that is very, very important.
And I need to answer.
And just to say that my point about Dr. Yu was said in jest, and I hope he takes it at that.
Okay, great. I mean, I want to quickly ask the question. I'll ask the final question to everybody else, and everybody else can chip in on this. And because this, I guess, is almost a test of where we all stand on the back of the 2020 elections. Do we all believe that on the back of the 2020 elections, that we are grounded in our faith, that in 2024, another dispute emerges, everybody is confident that we will head back to the court? Has this 2020 petition left us even firmer in our faith and our conviction that that is where to end? when there's a dispute, or has it done the opposite? I mean, anybody else can take this. I mean, this is just to the community of people in this participation. I mean, I just want to get a sense of where you all sit on that question.
May I start? I think, as I said in the beginning, I mean, for me, I look at the election, the outcome in terms of the decision and the process from a very forward-looking perspective. How does it affect the future conduct of elections? And I think when you look at it from that standpoint, in terms of the substantive law, yes, there's we are beginning to see a lot more clarity. I would prefer, however, that we actually codify this, right? Codify what the legal test is. Just as we have in section 20 of PMBC law 284, which applies specifically to parliamentary elections, we should probably just have one omnibus election law, new law made, that actually codifies the legal test very clearly. And if we're going to borrow from either section 20 of 284 and or Morgan versus Simpson from this decision, then yes, we codify that so that we have clarity. That helps future stakeholders, future litigants to know exactly what the legal tests are. Everything is very clear in a particular book. Now, from the standpoint of improving on election management, I don't think we've made much of an advance. And here is where I do have a problem, because as I said at the beginning, election petitions put not just the 2 main litigants on trial, also on trial is the judiciary, because it's an inherently political matter. That's why the judges, aware of that, allow the cameras and the videos into the courtroom. Once, only during election petitions. Normally they don't allow that. But they are conscious of the fact that this is not just a legal matter, it's a political matter, and the generality of the public has a keen interest in it. In fact, the public, the voters will. They are the real parties in interest. The voters are the real parties in interest. That is why the court doesn't just annul elections if you can show that there's an illegality. It says, show that it was so substantial that everything is indeterminate, or show that there was an effect on the outcome. It must respect the will of the voters. So voters are the reason why the courts showcase the whole process, right? Also on trial is the EMB, the election management body. Its conduct is on trial. And for me, that is why courts are allowed. Courts, when it comes to election petitions especially, courts even in the common law world, are not just, they don't see this as just a pure adversarial process. They are inquisitorial. They have powers of scrutiny. They can call witnesses even when you haven't called them. In election petitions, it's allowed. It's done. It's done universally. Done. So when the EMB, who is also on trial actually, and who really is the one person, the one legal institution, statutory body, constitutional body empowered to conduct an election, is not asked any questions. And I don't mean following civil procedural rules by the petitioner. The court itself could have asked them a few questions. After all, the court talks about the EMB in its decision. Right? The EMB admit that it made an error. So what if you, just for the sake of the public, the court takes over at that point and says, look, EMB, do you admit that you made some mistakes in this on this form? Yes, my lord, yes. That itself is sufficient. I'm not saying that we throw all civil procedure aside. After all, we make amendments when it comes to election petitions. That is why even constitutional violations, like we didn't sign in our constitution, it says we must sign the training of some must sign these things. But it's a constitutional violation, but it doesn't annul an election automatically because it's an election petition and we apply certain rules that are different. So making a modification to cater for the peculiar nature of this matter so that the public too is satisfied that justice was done and they see it, I think is something that we missed. We've missed that opportunity by being a little too technical about this matter, right? That has been my whole point. And I think that going forward, I think apart from improving on the substantive law and codifying it, we should really begin to find a way of letting the generality of the public be satisfied that the EMB has been held accountable. Last point about where the EMB is also normally not held accountable is that the election petition only takes cognizance of those kinds of irregularities that rise to a certain level or scale that can actually change the election. But what if they don't rise to that level? Does that mean that it was good? That doesn't mean that we should have, all the irregularities that are happening should take place. No, because those irregularities may not end up in court. They may actually lead to violence at the polling station or violence at the collation center. What do we do with those things? We must have a different process, maybe an administrative process for the EC itself to hold its own officials to account for those kinds of violations. And maybe the court should have used its remedial powers to actually tell the EMB to go and do those things too.
Let me see if I can get a quick word from Lawyer Kotuampao if he's expecting any reforms on the back of.
Let me make the first point. If you have a case of this nature before the highest court, and the case raises substantial issues of law and fact, then you can expect that in coming out with a judgment, the Supreme Court would make, apart from making a decision, make recommendations based on some of the issues of fact that were raised in the course of trial. Now, the point I'm going to make, I say it without any ill will, but I honestly am of the view that legally speaking, there was no case before the Supreme Court. There was no petition.
Oh my God! No. Even a judge, even a justice of the Supreme Court who participated in has said that there was a reasonable course of action that was brought. And that is not what you are saying. Is not what the court said.
Okay. Dominic, let him land quickly.
My point here is that if you go to court claiming that neither party won the election, and when you are asked this basic question, what are your numbers? You say you don't know, or you say you have it somewhere in the house, and so on. What about the petitioner? What are his numbers? You don't know. What are the total number of votes cast? You say it's now that you go and meet and discuss it. Then why are you in court? I'm saying that where a substantive case or grievance is brought before the court, then the court, in trying to address that grievance, even if it gives judgment against the petitioner, may see the need to make recommendations. I'm saying that in this petition, there was no case for the court to address in terms of, yes. But yes, they could raise questions about the EC's accountability and so on, and how it came to giving those funny numbers. That is a legitimate issue to be raised. But I do not think that if that is their concern, you address that issue by way of an election petition. You address that issue.
Mr. Kotuampao, should the court have taken the opportunity, as Prof has said, to at least ask the EC questions about what you call the funny numbers?
I'm not very sure about that. The court could have, but I do not take the view that the court had a legal or judicial obligation to do so. I don't think so. Now, it is also the case that I believe that the EC itself, together with the relevant stakeholders, need to do a closer review of the actual procedures and processes that they took to arriving at the final collation of results in the 2020 elections, and to see whether there is need for some reforms. I can see quite clearly that there may be some reforms in CI-127. Looking at it, I can see that from this experience. But I'm saying that given the issues that were brought before the court, frankly speaking, the court had very little opportunity to make recommendations for reform.
Okay, thank you very much. Dr. Ine, in fairness to you, I give you a minute to wrap up for us. I know you're on the other side, so just quickly a minute on what you just said.
Yes. Oh, thanks, Evans. I just wanted to put it on record, and I have said this before, that the nature of the animal that we're dealing with in 2020 was radically different than the nature of the animal we're dealing with in the 2012 election petition. And I'm surprised that very seasoned lawyers and academics have failed to understand the nature of the animal that we brought, to court. All right. I keep saying that, a violation of the Constitution, a declaration that a person has not attained the constitutionally mandated threshold in order to be declared, winner of an election. Okay, is in itself a very, reasonable course of action to bring before the Supreme Court of the land. And that was the matter that was brought. And if you look at the election petition, the petition was very clear about the nature of the actions, undertaken by the Electoral Commission that showed that Nana Addo Dankwa Akufo-Addo did not, obtain more than 50%, of the vote. And then also, and I think this is a point that Prof made earlier, okay, the declaration that an instrument is null and void, okay, is a significant legal remedy that a petitioner can seek. So for instance, if you declare somebody based upon an instrument and the numbers don't tally, okay, that instrument cannot stand on the basis of Article 64 of the Constitution. And if a petitioner says declare that instrument null and void, the petitioner is basically saying that declare the election, null and void. And I don't see how that cannot be a reasonable course of action before the Supreme Court, in an election petition. So we need to take a step back from the politics and understand the nature of the animal that was brought to court.
Okay. Unfortunately, we've exceeded our time. And so, brilliant submissions. And I think there's some suggestions going forward on what we might see. I think even Agotompo agrees that the Electoral Commission must do some reforms in terms of its processes in the collation of the results. And I guess that is something that it may not be necessarily coming from the Supreme Court, but what we saw in the process in the court has exposed that as a need to reform going forward. And I want to say a big thank you. I opened the floor. I didn't get too many questions, but I think everybody then, I'm assuming that there is general satisfaction with what you've heard. And it has been really, really insightful. And I've learned a lot from Dr. Justice Alfred Mavijange. Is a legal advisor, International Commission of Jurists, who shared his thoughts with us about the Malawi experience and the standard of proof, really, which we have dealt with quite extensively on this, and the need to clarify this going forward. The Prof said we probably need one law that specifies and clarifies this so there's no doubt around it going forward. He helped us with that. Felix Owo, Executive Director of the Electoral Law and Governance Institute for Africa. He had to leave us because there is a COVID protocol curfew where he is, that he had to quickly leave to avoid being in trouble. And so he took leave of us, and thank you very much. Mami Mensa Bonsu, I quite don't know where she disappeared to, but she started us off very strongly by dealing with the subject of judicial independence, and we are grateful to her. She's a CDD-Ghana D&D Fellow in Public Law and Justice. Professor Kofi Aboji had an emergency meeting, and so he could not join us. But of course, you've heard Dr. Dominic Ayine, MP for Bogatanga East, member of the ex-President Mahama's legal team, Yao Pom, private legal practitioner, member of the President Akufo-Addo's legal team, and of course, Professor H. Kwesi Prempeh. Just putting my journalistic hat on, and I know a lot of my colleagues are monitoring this. This is going to serve as great fodder for a lot of controversial conversations in the news going forward. And so all of you prepare. I'm pretty sure people will be calling you very soon to expand on things that have been said. Prof, stand by. Kojo Asante is one that I don't envy because he takes all the calls. And I'm pretty sure on the back of what CDD had just done here, CDD always, gives us a lot of food for thought. And this has been one of those occasions for that. I'm grateful, gentlemen, for joining us. Nick Opoku, I'm going to hand over to you to take over and navigate as close. Hello, Nick, if you're still there.
Yeah, I think I'm closing, and then we can move on.
Oh, yes. Hello, Kojo. Yes, Kojo, it's your turn. And I said, I don't envy you. I don't envy you because what you've done today is give us a lot of talking points for the next 1 week. And your phone battery is going to run down very soon. I'm pretty sure I'm going to call you. And so, Kojo, thank you for hosting us and give us a sense of where we go from here.
Thank you very much, Evans, for the brilliant moderation. For me, coming at the back of the post-election retreats that we had at Aqua Safari just last week, this, I think, is really complimentary. Some of this discussion came up, and there were very strong recommendations, and I think there's even a few more here that we could add to the communique that hopefully should come out tomorrow. But just to say thank you to the panelists, our colleagues from Kenya and from Malawi for agreeing to join us, and our distinguished panelists here in Ghana, my own brother Yaopon and Dr. Aini, Mami Mensabosu, and my own professor here. The Honorable Agotafao, also chipping in. Thank you all, and also to our audience, both on the Zoom call, but also on Facebook Live, who are watching us on YouTube. Also, thank you for being here. I hope the conversation continues. This has been really, really useful, and I think that we should just continue to engage, and then also engage with all the institutions to promote our democracy. So we'll come your way again with another opportunity to discuss our democracy and our development. I bid you a very good evening. Thank you.
Thank you.
Thank you.
Thank you.
Yes.